Good evening. Happy Thursday. Tomorrow's Friday. Hope you're ready. So, State of Texas versus Earl David Warden. There has been a motion. This is a motion for a new trial. What does that mean? What that means is that Earl has filed a motion in the trial court, the court that actually tried his case. And he gets to make some allegations. And he needs to suggest to the court that something akin to one of these various factors was in place. Now, we know that he had counsel, so it's probably not A, although in reading the case law, ineffective assistance of counsel is grounds for a new trial. When the court has misdirected the jury about the law or has committed some other mistrial error likely to injure the defendant's rights. Did the court give a jury instruction that was wrong about the law, or otherwise tell the jury some point of law that was incorrect? And where this would come up normally, because you're asking the same judge, who tried the case to make the determination that he made a wrong point of law. Now, where this normally comes up is where the judge states this is what the law is. He states something about the law. This is what the law is. And then shortly thereafter, i.e. within the 30 days that the defendant has to file a motion for a new trial, there is some sort of a ruling in a superior court, like in the Court of Appeals or the Texas Court of Criminal Appeals, which is Texas's version of the Supreme Court for criminal cases, or in the United States Supreme Court. Or maybe the legislature put out some new law that clarified what they intended, or something has to come out where the defendant can say, "Look, judge, you were wrong." Now, the other way this will work is if the judge did make an error of law when he was instructing the jury, this will preserve that error of law for an appeal. So you file your motion for a new trial. The trial judge has to rule on that within 75 days of the date that you were convicted. And then if the judge denies it or doesn't rule on it, then you can appeal the denial and say, "Look, the court below me made an error of law," and the Court of Appeals can then say, "Oh, well, you know what? We agree with you." So that's a helpful way that might come into play. Where the jury has been decided by lot or in a manner other than fair expression of the juror's opinion. By lot means like if they draw straws to say whether he's guilty or not, or whose version to take, or they leave it up to chance in some way. When a juror has been bribed to convict or has been guilty of any other corrupt conduct, that's pretty self-explanatory. If what's that guy's name? Dougie slipped a juror $100. Well, judging by the way he dresses in the car he drives, I doubt he has $100 to slip. So let's say he slipped him like $2 and a half-eaten crayon. Then that might work. When a material defense witness has been kept from court by force, threats, or fraud, or when evidence tending to establish the defendant's innocence has been intentionally destroyed or withheld, thus preventing its production at trial. This could be a Brady violation where the prosecution doesn't disclose material or any exculpatory evidence. You could raise that in this. When, after retiring to deliberate, the jury has received other evidence, when a juror has talked with anyone about the case, or when a juror has become so intoxicated that his or her vote was probably influenced as a result. Now, we know that Dougie talked to at least one juror. We know this because my understanding, and I'm told that I'm wrong, but this is the way it was originally reported to me, and I don't think it really makes that much of a difference. My understanding is that the juror that Dougie talked to was excused, was not allowed to participate. and it was a potential juror, and all these other excuses. But in my there is an appearance that there at least was an attempt at jury tampering by Dougie, because he's a piece of shit, and that would go a long way. Like if Earl points out that, hey, look, this dude Dougie, who has tried really hard to F me over in the past. Remember the incident where Dougie was handing out those crayon wanted posters about Earl at a Open Carry Texas event, and he got chased out, and he ended up getting pulled over by the police because he'd removed the plates from his car and otherwise acted like an idiot. So Dougie has a big hard-on for Earl for whatever reason, and Dougie isn't above breaking the law to try to get to Earl. So that's a very strong reason or basis for their motion. And when the jury is engaged in such... Oh, another one. If the jury has received other evidence. One of the things in my video that I'm still not entirely 100% sure that I went over this in the video. The quick turnaround, it wasn't really quick. It did take the jury a half a day to actually come to the guilty verdict on the second day. Initially, I was like, wow, it was like basically deadlocked at 7-5 or 6-4 or 6-5 with one uncertain or whatever. It was some hung jury number, roughly 50-50, roughly. And then the next day, all of a sudden, boom, guilty. That my first thought, and I expressed this on Discord, my first thought was somebody went home and Googled Earl David Worden, and they saw he was a registered sex offender, and boom. But then that doesn't really make sense to me in hindsight, because it took them half a day still to convict. But that could be something. I mean, they could have found out that one of the jurors did in fact Google Earl. When the jury is engaged in such misconduct that the defendant did not receive a fair and impartial trial, like if jurors were asleep, or if jurors were daydreaming, or doing hangman or tic-tac-toe instead of actually listening to the witnesses and observing the evidence. Or when the verdict is contrary to the evidence in the law, when that would be something like where the prosecution does not actually prove their case, but because the jury doesn't like the defendant so much, they find him guilty anyway. Even though if you actually look at all the evidence impartially, you say, like, this doesn't add up to this guy being guilty. And there's all this contradictory evidence that adds up to him not being guilty. There's no way a reasonable jury could have come to the conclusion. Now, this is not an exhaustive list. This is a what was it? State versus Herndon. Anyway, I think it was State versus Herndon that says it's not an exhaustive list. They can pick any of these reasons or any other reasons that would tend to indicate that justice had not been done at trial. Now, if they want to get a hearing, that's State versus Smith, they actually have to introduce new evidence that can't be adduced just from the record. So, like if they're saying that the court misdirected the jury about the law, that's just from the record. The court doesn't have to give them an actual hearing on the motion. So, if we see a hearing pop up, we'll know some things. We'll know, number one, that there are affidavits and there's new evidence. And at the hearing, the judge can proceed just on the evidence, just on the affidavits, or he could adduce evidence in really any other way that you could normally adduce evidence. They can call witnesses. There can be experts. There can be video evidence or documentary evidence or photographic evidence. There could be all sorts of evidence, just like there was a trial at this hearing, to see whether or not there should be a hearing. And the basis is there has to be a reasonable reasonable. He has to establish the existence of reasonable grounds that that he could be entitled to relief. Now, the purpose of this hearing, this motion, is to do two things. Number one, if the court grants the motion, then there's going to be a new trial. And it could be a new trial, like a new entire trial, like to determine whether he's guilty or innocent, or it could be a new trial on the sentencing, on the punishment. Now, because Earl stipulated to the punishment, he reached an agreement with the prosecution. It's probably not going to be a trial on the punishment. It would probably be a whole trial, brand new trial. So if the court grants the motion, Earl gets a whole new trial. And hopefully the court will keep miscreants and ne'er-do-wells like Dougie out of the courtroom. And to be perfectly hopeful, I hope the court keeps out people like that Gray guy who was filming and hanging out, being all weird. That's distracting. I hope they keep people out like Diddle and Jack, because all these people around there, it just seems like every single one of these people has negativity and drama just surrounding them. Let Earl have a fair trial, for the love of God. Let the man have a fair trial. Let the victim have a fair trial. And I have hope for this since the get-go. Let's let the justice system do its work and do it best. So like I said, if the motion is granted, he gets a new trial. If the motion is denied, or if the trial court fails to make a ruling within 75 days, it's considered denied, and then Earl could appeal that denial. And then the Court of Appeals would then look to see basically for abuse of discretion. It is exactly for abuse of discretion. Basically only if the judge's decision was completely unreasonable. There's no way a reasonable person could come to the conclusion that it was correct to deny that motion for a new trial. So we do not have a new trial yet. The way it's supposed to work in Texas, is just if there's reasonable grounds that the defendant could have been denied a fair trial, reasonable grounds that he could have been denied a fair trial. So it's very lenient. It's incredibly lenient. As long as Earl can put forth some allegations, some affidavits showing that there was some sort of misconduct around the whole trial, I'm going to guess it's going to have something to do with either, I don't think it was ineffective assistance of counsel. It could have been. I don't think so. I wouldn't believe that to be the case. It could be, I think it's going to have something to do with the jury. And either they found out, like the jury Googled Earl, or Dougie actually managed to compromise the jury, or it appears that Dougie compromised the jury. Or maybe someone else did, because I wasn't there, but I did see enough things to know that it didn't look right. I would have been uncomfortable as an attorney representing a defendant in that environment, and I would have asked that the courtroom be cleared, and I would have argued that it was very distracting to have all that bullshittery going on. That's what I would have argued. I don't think I would have prevailed, but I would have argued it, and I would have preserved the appeal. I would have preserved the objection for appeal. One thing to note is that Earl does have a new attorney for this motion, so there might be some ineffective assistance of counsel, but I don't see it. Earl's counsel didn't call a lot of people, but I mean that could be a strategic kind of decision, you know. So I don't see it, but it could theoretically be it, or maybe Earl just didn't like the way his attorney performed and wanted a new attorney for the motion for reconsideration. Maybe he was dissatisfied with having hired the second best defense attorney in Harris County and chose to hire the best criminal defense attorney in Harris County. I'm not sure, but he does have a new attorney. So what we're looking for is within 75 days of 12/16/2022, or was it 12/15? Hold on a second. It was 12/15. The judgment was 12/15. So epoch days and we're going to actually go back to 2022, and December 15th was 16 days. 16 days out of 75 means there's 59. So day 59 would be somewhere around the 28th, unless my math is entirely off. Somewhere around the 28th of February, the court will have to have ruled on this particular motion. So, best of luck to Earl. That doesn't mean I like Earl, but I really did not like what Dougie did. I think I expressed it in the video I made, and I just really want a fair trial. I want a fair trial for Earl and for the victim. And anyway, I think I've made that point. Thanks for watching. I'm rambling. Have a great day.